Good afternoon, everyone. Thank you for joining us for today's Lunch and Learn. I'm Lauren Smith with the International Franchise Association, and we have a great 30 minutes lined up for you. Before we begin, I would like to remind everyone that we are recording today's webinar and will make it available later this evening on community.franchise.org. If any questions for today's speakers, please add them to the chat box and they will be addressed toward the end. Today's topic is managing personal information in the franchise relationship, and it is brought to us by Greenberg Traurig. Here to provide today's discussion is Tyler Thompson and Brett Permesly.
Are you going in there?
Yeah.
Okay.
Thank you all for joining us today, and thank you to Greenberg Traurig for sponsoring today's Lunch and Learn. I'll go ahead and turn things over to you, Brett.
Thanks, everybody. Good afternoon. Like Lauren said, Brett Permesly, I'm in the New York office of Greenberg Traurig. I work in the franchise licensing and distribution group. I think everyone can kind of agree that personal information is more of an asset in the franchise relationship than ever before. And simultaneously, there's been an increase in the number of domestic and international laws focused on this type of information. And so we've been getting a huge increase in requests from our franchisor clients to really do a deep dive into how personal information is used to make sure not only that it's being used most effectively and utilizing it as an asset, but also making sure that there's no resulting liability from doing it incorrectly. So Tyler, who I'll allow to introduce himself, has really been a huge help to our group in helping franchisors deal with these types of issues. So Tyler, if you want to take it from here.
Sure. Thanks, Brett. Yeah, my name's Tyler Thompson. I'm a data privacy and cybersecurity shareholder in the Denver office. As Brett said, there's been a lot of development here in this area. It's something that we're dealing with on literally a daily basis. Here's our high-level plan for the day. We've got a lot to go through in 30 minutes, so let's get right into it. First, let's talk about why is this important. So, personal information, that's that customer data, personally identifiable information, personal data. These are all terms you might know it by. It also includes employee data, and managing this information is important to the franchise relationship. You have a lot of new risks happening right now. So if you're familiar with privacy laws in the US, you know that there's a number of comprehensive state laws that came online this year. California, Colorado, Connecticut, Utah, Virginia are all going to be online by the end of 2023. We also expect by 2025 there to be between 20 and 25 states that have these comprehensive state privacy laws that will affect the use of this information. Enforcement has never been greater. We're seeing Colorado enforcement start to happen. I just had a client get a letter this morning on that. And also these new laws, what are they trying to do? Well, they're talking about how this personal information can be used. How can it be stored? How can marketing be done? What kinds of notice and transparency do you need to give to individuals? So beyond the laws, there's also some just very practical concerns about reputational damage, right? We'll talk a little bit about data sales, and that's something that if you've been dealing with these privacy laws, you know is a common term. You don't want your franchise relationship to end up on the cover of the New York Times saying, X brand has been doing unauthorized data sales. That's not a good look for anybody and certainly for any brand. So really the big question is what happens if we get this wrong? If we don't think about it, if we don't handle it correctly, what are we looking at? Well, regulatory penalties is a big one. Again, there's a lot of different laws here, so we can't go into each, but let's just talk about two of the biggest. So first is the California Consumer Privacy Act. The biggest penalty to date, there's a $1.2 million violation. Also GDPR, another huge regulatory stick, and 4%, up to 4% of global revenue. So again, even though you might not be in California, you might not be in Europe, these are some of the regulatory structures that other laws are also basing on. So you have to look at this as this is your possible penalty in the regulatory space. Data breach, always a big one. We've seen some big high-level data breaches in the news recently, if you've been following that. This is also an issue for a franchisor and franchisee relationship. What if there's a data breach of this personal information? Some of that sharing between a franchisee and a franchisor or vice versa, every time you share data increases the possibilities or the vectors for a data breach. So that's something to keep in mind, is that the more complex your structure is, the more likely a data breach might be. Useless marketing data, I think this is something that not a lot of folks think about, but especially if you have international concerns, but even for some contexts here in the US, if you're not collecting the proper consents, you're not handling this the right way, that marketing data might be useless, or it might be useless to another concept that your franchise has. And so that's something to think about as well, is how are we intaking this data? How are we getting the proper consents? If we're not doing that the right way, a lot of this value of the data might be lost. And again, that reputational harm that we talked about, that's something that I think is a little bit under the radar, but it may not be that $1.2 million penalty that's the big problem for your business. It may be, the reputational harm from a large data breach, or from, that article in the New York Times that really changes things for you. There are some specific examples here in a number of these fields, and I just want to highlight each of them a little bit briefly. So for the GDPR, we talked about that and the regulatory penalties there. There has been a case out of Romania where misuse of information by a franchisee made the franchisor liable. So again, think about how that's a little bit unique. If this is a franchisee doing something, but that liability extended to the franchisor. Data breach, there's been a lot of these. One to look at specifically, franchisee was storing data in an unencrypted format. Again, the franchisor ended up being liable for that. So this is another case where the actions of a franchisee can affect a franchisor. And then marketing, TCPA, this is calling and texting, again, where the franchisor was liable for the actions of a franchisee. This data flow, this is actually, believe it or not, a relatively simple data flow. But it's on here to show you the type of relationships you might have both between a franchisor and a franchisee, and some of these external parties, different types of data with both the customer data and employee data, how this might be flowing around. So you can see that even with a relatively simple structure, there's a lot of data flows here. There's a lot of external parties to consider, multiple different types of data to consider. And so this is something to keep in mind. If you don't have at least a high-level chart like this for your organization, you have to ask yourself, do you really understand where data is going and how it's flowing around my organization? Let's talk a little bit about the data processing roles themselves. So these are that controller and processor roles. Now they have other names in certain privacy laws, especially in the US, but in general, you will hear people talk about controller processor. The controller, that's your data owner, right? That's an easy way to think about it if you're not familiar with this. These are the folks that control the purpose and means of processing. And so the controller has a lot of freedom with what to do with that information. The flip side of that is they have a bigger compliance burden, which we'll talk a little bit more about. The other side is the processor or the service provider. I think by calling it a service provider, which is the defined term under many US privacy laws, you kind of get what these entities do, right? This is an entity that is touching that personal information, they're processing it, but only for a limited scenario. They're only doing it to service the controller or provide services to them. The flip side is you have that limited scenario, but you're also not as responsible for compliance obligations. So what are the effects of a processing role? So when you're thinking about this, is your franchisee your controller? Is your franchisor your controller? There's a lot of different variations, and we've done all types of these variations for a number of clients. But let's think about some of the effects of the different processing roles and how labeling somebody or an entity as one thing or another can affect what they're actually responsible for, what they get to do with the data. So again, your controllers, they're responsible for most of those compliance elements. What do we mean by that? Well, that privacy policy, right? That's a really common thing. It's publicly facing. What about data subject requests? If you've been thinking about privacy, you know that folks have the right to access their data, have the right to delete their data. Ultimately, it's the controller that's responsible for making those requests happen and facilitating those. There's a lot of back-end things as well. For example, if you're international, you might have to have a comprehensive data inventory. That's another thing that's a responsibility of a controller. So that controller compliance burden is very large, but you get to do more things with the data as well. So what about the processor side? Again, basically, we're flipping that. Usually a processor can't use that information for their own purposes, right? They have a very narrow defined role, defined scope of what they can use personal information for. And you can see how you label this can really affect what people are going to do. So, having a franchisee be a processor means they might be able to just collect information like in a physical location, but really most of that data goes back to the franchisor, who then controls a lot of what they do with it. We also have clients who have totally flipped that, where the individual franchisees are the controllers. So those franchisees have a lot of control of that data, what they can do, who they market it with. At the same time, the franchisor, they're a processor, so they're going to have a limited role basically servicing the franchisees. There's also some unique structures that I can't get into in the amount of time that we have, but it's worth noting, like separate controller relationships or a joint controller relationship. Those structures might be right for you as well, particularly if you have a really complex set of franchisee structure, or if you have a lot of international elements. those structures might be what's correct for you. Let's move on. Let's talk about the actual franchise agreement issues and how we're going to deal with this in the franchise agreement or in other documentation between, the franchisor and the franchisee. This is something that is a big problem right now, is a lot of these franchise agreements and the associated, operations manual or what have you have just not thought about this, or they've not thought about data in enough detail to really work under these new comprehensive privacy laws. So a big task right now is going in and putting in a lot more rigor around your data processes and controls. So let's think about general data rights and ownerships. How are we going to set this up? This is what we've been talking about for who's got what role, who controls the data, who owns it. That all is going back to that processing role piece. What are some key considerations here? Well, you need to make sure that you paper for the right processing role. Now, whether you're a controller or processor, you can't just decide that via contract, right? It's important to keep that in mind, that you have to have the facts line up. This is a factual determination, typically by a regulator, that's going to decide if you're a controller or a processor. That being said, you can do a lot with the contract, with the structure of your organization, with structuring your data sharing to kind of push you into one role or another and set you up in the right way. So there's no reason, if you have forethought on this and you think about it, that you can't set this up in the right way and position your franchisor and franchisees or master franchisees the way that you might want them to be positioned. So paper for those processing roles. Do that, set that up in your franchise agreement, your operations manual, your brand standards, whatever it is. Let's talk about who has what rights and data, and let's really be clear about who has what role. Plan for frequent amendment. We've been talking about this. This is something that there's a lot of new privacy laws. There's going to be a lot more. So this is going to keep changing. So how are we going to handle that? Are we going to go and redo the franchise agreement every time there's a change? Or do we need to implement some structures that allow us to change this unilaterally in the case of new laws, because new laws are going to keep happening? Obviously, addressing liability and indemnification, who's on the hook, right? There's going to be an issue here. It's only a matter of if, it's only a matter of when, not if. And so making sure that you know who's on the hook for that is really important. Your key sections, these are probably not new to folks on the call, but your key sections when you're dealing with these type of processes, make sure limitation, liability, indemnification, the data storage and access, who has the rights there, who can actually access the data, post-termination considerations, what happens if the relationship dissolves. Now, these are not legal only issues, right? I know we have a lot of folks on the call who are not lawyers or not in that specific space. This is something that everybody can think about, who's going to be responsible for these items. I encourage everybody to issue spot it, especially because there's a lot of relationships that just haven't thought about this in enough detail yet. And then your data processing addendum. These are required contractual provisions. These applicable law, these new laws actually require them. You need them in place between a controller and a processor. If you don't have them in place, you've just immediately violated the law. So this is something to think about as well. You don't have to know what should be in there. You don't have to be an expert in privacy law, but you should know that there should be a data processing addendum or some sort of comprehensive set of privacy provisions somewhere located in the relationship. The operations manual. So, you might call this the brand standards or something different, or you might have both. But really what we're talking about here is these are the documents between the franchisor and the franchisee that are a little bit easier to change, right? They're a little bit more flexible. This might be where you want some of your data provisions to live because of some of the restrictions that might be in your franchisee agreement. So allowing for that unilateral modification so you can keep up with some of these new data issues, that can be crucial in this space. What are your key sections? What are things to think about? Again, marketing. Who can use this data? Customer data is a really common one. Who can use customer data? Who can market to customers? If it's not specifically spelled out somewhere, maybe anybody can do it. Maybe nobody can do it. So we need to spell that out. Data subject requests. Again, if somebody says, delete my data, I want access to my data, who's going to be responsible for that? That can be a big lift, especially if you're a popular brand. You could get hundreds of these, maybe a couple hundred of these a year. So making sure you know who's responsible for that and who's helping whom, that can be really crucial. Again, that data storage and access. When a customer signs up for a loyalty program, when they make a purchase, where does that data live? Who has access to that? Can the franchisor access that? Can the franchisee access that? Can somebody export, an Excel document with every customer's email in it? Understanding how that works is crucial. That's something to make sure that it's clear in that operations manual or another document. And again, inventory, that might be international. Your incident response plan, this is a huge thing. Okay, we've had that data breach. We've had the ransomware attack. The point of sale terminals are down at all the locations on the Eastern Seaboard. How are we going to respond to that? who's going to be in charge of, making a statement to the press? Who's going to be in charge of securing outside help to come in and remediate that breach? If you haven't talked about it, if you haven't planned for it, if it's not in writing somewhere, you should assume that it's just not going to happen. And finally, that audit. Who needs to audit whom to make sure that we're doing the right things with data? We want to make sure that somebody can actually come in and check and make sure that this is happening the way it should be. Who has those rights and how are those rights exercised? Compliance obligations. This is a big piece with the different processing roles. Let's talk about some of the actual compliance obligations and what does it means. Privacy policies and notices. We're all used to that big privacy policy on your website. Make sure that that privacy policy, it has all your activities covered. This is not just digital, right? This is not just the information that somebody enters in an app or on a website. These now need to cover the information that's collected at a specific site. So if you have, locations and they're collecting customer data, your privacy policy needs to talk about that. And those locations might need to know what's in your privacy policy, right? So they can actually adhere to it. Don't forget your employees. California and international jurisdictions, they're requiring a privacy notice for employees. So this is something where if you have a lot of locations in California, you have international jurisdictions, what notice are we giving to employees about how we're dealing with employee data? Somebody needs to be in charge of that. Somebody in the relationship needs to be handling that. And then the provision of these notices themselves, they need to be at the point of collection. So this is where you're collecting that data. Having it just, in the footer on the website, not enough. We need to think, how can we get this more in the customer's face, right? Especially at physical locations, this can be challenging. So what can we do with a point of sale terminal? What can we do with a QR code? What can we do with putting a notice on a receipt? All things to consider. Data subject requests, we've talked about this a little bit. And again, new privacy laws, you have rights to say, hey, delete my data, access my data. Who's going to handle this? There's a lot to take in here on the slide, so I wanted to point out just a couple of specific things. What about franchisees? Are they going to know how to deal with these requests? We might need to train them, right? We might need to train them about what happens if somebody comes up to somebody at a register and says, you need to delete my data. You might have to train somebody to say, hey, we need to point them to the privacy policy. We don't want your average person at a point of sale terminal trying to help them out and delete their data and find data for them. And you might have to, the franchisees might have to pass those requests on. You might have to pass that request on to the franchisor. So make sure you get some training there. Make sure you're thinking about this. And everybody in your organization at least has a high level understanding of, oh, if we get this weird question about data, we know that we need to send them to the privacy policy or we need to send them to corporate or what have it. Opt out of sale is another huge one. The sale definition of these new privacy laws is not what any normal person would think of for sale. So make sure you understand that. And what does that really mean? Well, there might be different types of opt-outs that we have to provide for people, even if we're using cookies on the website. So make sure who's responsible for that. If franchisees have their own websites, are they required to provide these opt-out of sales? These are all things that you need to think about and make sure that somebody is responsible in each point of the chain for these requests. Marketing and loyalty programs, this is a big one, right? Who's responsible for those in consents? So if you're going to text people, where did that consent come in? I mean, that's a complex consent that you need to get to text people or call people legally. Who's responsible for that? What if we're getting a phone number at a specific location? For example, loyalty card, somebody fills it out and you'll sign up for a text program with this hand filled out loyalty card. Who's making sure that that card actually has the number on it? Who's collecting those cards? So if we get sued for this, we know we can produce the card and say, hey, they really did consent to that. These are all some of the details that you got to think about to make sure that you're handling these programs in the right way. What about tracking it? I mean, that's a big thing. We touched on it a little bit, but we need to think about that. How do we track these consents? How do we show that somebody actually consented? That's a big piece of it. And that bold piece there, I should just really highlight that a little bit more, that if you set up a specific consent, like a lot of times we'll have franchisors say, this is our consent for email marketing. This is our consent for text messaging, for joining our loyalty program. We need to have this language in place to join the loyalty program. Somebody has to see this language. How are you going to make sure that the franchisees are actually showing that language? Again, that's something to think about. Now, you might have a centralized point for that loyalty program sign up, but still think about how we can integrate that and make sure everybody's handling it the right way. Last point there on the slide, that financial incentive disclosure, not going to go into too much detail, but if you have a loyalty program, these privacy laws are requiring you to disclose this financial incentive as part of the loyalty program. So that's something that needs to be in your privacy policy. It's complex. Just realize If you look at your privacy policy and there's not something in there and you have a loyalty program, probably need to make that change. High level, think about employee data as well. This is just a chart to show you how employee data might flow through. I'm not going to spend a ton of time on employee data, but it's important to realize that employee data is subject to these laws as well, at least for California and international. So make sure that you understand who's responsible for all these same requirements before employee data. Got to understand that. Think about how tricky this can get, right? You have joint employer issues. You have really granular issues with physical locations. So you might say, okay, the franchisee, you're the controller, they're responsible for all that. But a lot of times the franchisor is still providing services to help manage that employee's time. Here's our tech platform to let people clock in and clock out. So you as a franchisor are still having that data. Got to make sure you're thinking about that, understanding the implications of that. Another thing is with this is setting up those reasonable controls, right? You want something where if you have a franchisee and they have a lot of that data, but the franchisor needs to be involved, let's set up a clear line for what employee data us as the franchisor should have. So we're not exceeding that line and getting into like a joint employer relationship, something like that, where we're going to have some tricky liability issues outside the privacy space. Let's talk about some final thoughts before we open it up to questions. We've got 5 key takeaways here where we're distilling this down into really 5 key points. So first thing to do, if you are now scared, a lot of times that's what happens with this presentation. People are getting a little bit freaked out. So step 1, just start with reviewing the franchise agreement, review your operations manual. That's a big piece of it. Look through the documents you already have in place. What are we saying about data? Who's the owner? Who is servicing who? Who's providing what to whom as far as customer data, employee data? Understanding that, let's understand where we are right now and what we have in there. If you don't have anything in there, that's okay. The other thing to realize is these might not be very clear provisions. Like a lot of older franchise agreements, this is a confidentiality provision, not a specific data provision. So understanding how that might be. Once you know the groundwork there, let's think about what modifications do we need. Do we need to make some changes to our relationship to make sure that we're papering this and handling this the right way? What about monitoring the compliance of another party? That's another thing. So the franchise agreement, let's say now we've thought about the changes we need to make, but let's handle that in the franchise agreement itself. First, let's determine that flow of personal information. So how in the franchise agreement, how is personal information, customer information, employee information, how is that flowing from one entity to another? Oftentimes with the franchise agreement, you can tell that, you can really understand that just by looking at those provisions. And now let's think about matching the party with the role. So, if once you have that franchise agreement, you understand how it's flowing, think back to our processing roles, right? This is the controller and processor. Let's match that up. Who needs to be what? Let's try to match that up and hopefully memorialize it in the franchise agreement or something like that. Number 3, consult the experts. This is not a shameless plug, I promise, but I really would say that especially once this gets more complex, once you've diagnosed that you've had an issue, bring somebody in that can help with this. A lot of times we see a lot of jurisdictional issues. So, folks, they just opened up locations in a new state or a new country. They haven't thought about the privacy compliance obligations in that state. So think about bringing somebody in who knows what you need to do for that new state, for that new country. Think about how that person can help you figure out the right processing roles, drafting the franchise agreement, ensuring compliance. This can just be a hard thing to do right off the bat without some expertise there. So think about really finding somebody who's an expert for you to come in and help with that. Determining the compliance logistics, you can see there's not even a subpoint here because there's just a lot involved, right? These are all those compliance things that we talked about. Your privacy policy, data subject request, marketing consents. How are we going to do that? Who's responsible? And let's figure out how we're going to give the individuals or consumers our employee privacy notice or our customer privacy notice. How are we going to go through these things? How are we going to walk through it? There's a lot of intake points and processing points for this data. There's really no shortcut for talking about each way that data is coming into the relationship, going through that and just figuring out who's responsible. Let's talk through it. I would encourage you to have this conversation with your franchisees if you have a good relationship there, because a lot of times what we've seen is the franchisor doesn't have a complete grasp of all the data types, all the different issues here. So having the franchisee be part of that conversation, even if it's just at a high level, can really help you determine who's the best party to be involved for each of these compliance things. Last but not least, memorialize. What do we mean by that? Have the stuff in writing. We've talked a ton about making those changes to the franchise agreement, making changes to your operations manual or your brand standards, but it's not just that, it's also the compliance piece of it. Do we have that incident response plan so we know what happens when there's a breach? Do we have our security and what we expect, franchisees or the franchisor, what security they're going to put around personal information? Do we have that written down? Do we have a procedure in place for when we get these data subject requests saying delete my data? Who does that go to, right? The other thing I'll say about memorialization is it can really help with that regulatory investigation. So if you get a regulator reaching out to you saying, hey, how are you doing this? We think you have some problems, showing that you've put some paperwork in place, that you have set processes, that's a really good thing. Even if the processes aren't going to be followed all the time, even regulators understand that processes aren't going to be followed all the time, but showing that you have a process and, hey, this issue, it was a one-off deviation from that process, but in general, our franchisees know how to handle this information. That can get you a lot of benefit with a regulator and really reduce a regulatory penalty. Also, documenting that processing duty. We've talked about it so much with personal information. Who's the processor? Who's the controller? Do we have anything anywhere that says that? Even if it's internal only, it's for our use so we know the decisions and the analysis we've made in the past. Make sure that's in writing and that it lives somewhere. Those are our takeaways. Really appreciate your time. We are going to respond to some questions as well. I will say that we have two blogs. We have GT's data privacy blog called the Data Dish, which if you Google that, you can subscribe, and also the Emerging Technology blog. We write about these issues all the time, especially specifically with the franchisee bent to them. So if you want to subscribe to that, you can get some information straight to your inbox and keep learning more about these issues. So some questions in the chat. So first question, in our franchisee system, both franchisor and franchisees are controllers of the information. Could we have one DPO for the whole network? Is it appropriate to have a DPO fund? This is a really good question that I'd consider more of an advanced question. So we talked about how there might be some different structures. So one of the structures that we talked about super briefly was a separate controller structure. So this is where your franchisor and your franchisee, they both have a lot of control and autonomy with that data. Neither of them is a processor. They both have a lot of rights in that data to what they do. So this question, that's the situation here, right? Both people are controllers. And then it's asking about a DPO. A DPO as a data privacy officer, that's a specific role under the GDPR and some international privacy laws. If you're talking about a GDPR DPO, they need to be very independent. So the question really is, could we have one DPO for the whole network? Is it appropriate to have a DPO fund? So one DPO for the whole network, sure. You could have one DPO for both the franchisor and the franchisee. One thing to remember here is under the GDPR, the DPOs have a lot of requirements to be independent. So if you have one DPO, but they're an employee of the franchisor or the franchisee, you have to question, or is that person independent enough to truly fulfill the obligations of a DPO? Now, it might be. I could imagine many ways that you could set this up so that the DPO is a franchisor employee, but they have enough independence so they could independently act as a DPO for the franchisees as well. But that's something to think about. It might also be easier to have a third-party external DPO if that's how you want to do this, because then the franchisees can reach out to them, the franchisors can reach out to the DPO. Because they're external, they inherently have a little bit more independence. So just keep in mind that independence element. Is it appropriate to have a DPO fund? So what I take this to mean is, some sort of, fund where we're collecting a little bit of money from each party and they're funding the DPO. Certainly appropriate. Again, just make sure that even the fund is showing that independence, right? It's not, hey, franchisees are paying for 90% of this. And again, this is going to change a little bit by structure, but you want to be able to defend that DPO is really independent and they're not going to feel beholden to one party or another to listen to their privacy recommendations. Really, really great question. Another question, what about the franchisor owns the Microsoft domain and the franchisees are storing data on the SharePoint controlled by the franchisor? So again, you have a kind of a scenario where the franchisor owns that domain, they own the SharePoint, the franchisees are storing data there. There's nothing inherently wrong with this, right? In fact, it's very common for like a franchisor to provide technology services to a franchisee. One of those type of services might be the storage of data. But even though there's nothing inherently wrong with it, If you don't have that relationship papered, if you don't understand the right roles there, who's doing what happens to the data if the relationship dissolves, who's responsible if there's a breach, that can get really tricky really quickly. So it's all about, have you thought about that enough to put some requirements in place around who's responsible for that? If you've done that, nothing inherently wrong with that. Could be a very advantageous relationship. Just got to make sure that you've thought through some of the issues and how it could go wrong, and that there's procedures there. Another question, what to do during an incident should be built into the incident response plan. Important to know the IRP in case these companies want to engage a firm for assistance in creating one. Yeah, again, I mean, we've talked about the incident response plan. That should really be your Bible for when you have a breach, when you have a ransomware attack, to the point of, we tell our clients they need to print this out and they need to have hard copies of it because their systems might be down, right? So having a hard copy of your incident response plan with the appropriate folks' information in it, has your outside law firm's information in it, has your forensic investigators' information in it. When you might be, looking and handling this off a paper copy, do you know your chief technology officer's cell phone information by heart? Can you contact your public relations firm? Can you contact them if their contact information is on your computer and your computer is locked out from ransomware? All these things, that incident response plan is so important. We could talk 2 hours just on that, but great point to highlight the importance of the incident response plan there. I think that's all of our questions. So just like to thank everybody again for coming in and listening, and please reach out if you have any other concerns.
Thank you. Thank you so much, Tyler and Brett. This was excellent content and excellent feedback from all of you. We really do appreciate it. Again, this webinar was recorded, and along with the presentation deck will appear on our website early this evening. You'll be able to find that at community.franchise.org. Thank you very much again to Tyler, Brett, and the Greenberg Traurig team. And again, thank you to everyone for tuning in. Have a great rest of your day and stay safe and healthy. Bye.
Excellent.